Good afternoon. Good afternoon. Good afternoon. This is being videotaped and live streamed. Please turn off your telephones. And it is, if you'd like to share that information with friends, colleagues sitting at home, Susanna back there will tell you how. But it will be posted on the Institute YouTube channel beginning hopefully tomorrow morning. Welcome, and welcome especially to the students of the Alex Pilibos High School in Hollywood and the law school students, and all the rest of you too. This is really special because I've got a couple of observations. You know, when somebody tells you that a program just a week after school starts is a bad idea, tell them that it's not true if you pick the right guests. And if they tell you it's really hard to program on themes that are really, really current and in the news, tell them that's not true either, because unfortunately these themes, human rights violations, government responsibility and accountability, are always in the news. And you know, yesterday and the day before have been particularly horrid in that sense. So I'm sorry to say we're very current. Our two guests today, and really we do have two guests, are very special people, and in a way they're an antidote to all of the cynics responding to today's news. Both are in the business of giving voice to the voiceless and protecting the victims, not as do-gooder outsiders, and that's the part that is very important for me, but as people who try to bring institutional change, lasting change, trying to change local conditions, local situations, local power structures. Our speaker today, Nick Koumjian, is an international criminal prosecutor. He, following the nomination by the United Nations Secretary General Ban Ki-moon and the approval of his Supreme Council of the Magistracy, His Majesty the King Norodom Sihamoni, he was appointed as new international co-prosecutor in the extraordinary chambers in the courts of Cambodia. I don't usually read this kind of introduction. I'm doing it intentionally in order to share with you the gravity and the seriousness, not just of the individuals in the positions, but of what they've taken on. Prior to his appointment, Mr. Koumjian was senior appeals counsel for the prosecution of the former president of Liberia, Charles Taylor, at the Special Court for Sierra Leone. He represented Abdallah Banda and Saleh Gerbil before the International Criminal Court in a case involving the situation in Darfur, and he assisted victims from the Ivory Coast on a pro bono basis. And he was previously principal trial attorney for the trial of Charles Taylor, and he headed the UN-funded Serious Crimes Unit in East Timor. He was a trial attorney at the International Criminal Tribunal for the former Yugoslavia and State Court of Bosnia and Herzegovina. And before entering the international arena, Mr. Koumjian worked as a prosecutor in LA for 20 years. Hannah Garry, who very kindly partnered with us, and this program is being co-sponsored with the USC Gould Law School. Hannah Garry is founding director of the USC Gould's International Human Rights Clinic, which gives students the opportunity to work on projects and cases, both local and international, which confront the most pressing human rights concerns of our day. And her areas of teaching and research include international criminal law, international human rights law, international humanitarian law, and international refugee law. Never mind, these days all of those sound like oxymorons. I'm really pleased and grateful that Hannah Garry has agreed to be the interlocutor today with Nick Koumjian, and thank you all for coming. Please.
Okay, so can you hear me? Thank you so much for that kind introduction, Salpi. It really is myself who is so pleased and grateful to be in this position today, where I get to sit here with Nick Koumjian and talk with him about his incredibly important work as the international prosecutor at the Extraordinary Chambers in the Courts of Cambodia. I guess maybe perhaps to save time, I'm just going to refer to it as the ECCC moving forward. It's quite a mouthful, that jurisdiction. And we're going to have a bit of a dialogue today with regard to Nick's work. And I thought we could structure the dialogue in the ordering, basically, of the title for today's discussion, which is Decades After Genocide, Is Justice Possible? And then following a few questions that I'm going to pose to Nick, I'd like to reserve some time for all of you to get to ask a question or two, and I will do my best to keep us on track. As we move into Q&A time, I'll give a few more instructions with regard to how that will go. So again, I just want to thank you for the honor of being here, the Institute of Armenian Studies. It's really a pleasure coming from the law school to get to co-sponsor this event today. And so Nick, I thought perhaps we could start our discussion with just a little bit of background about what you've been doing at the ECCC since you were appointed at the end of 2013, I believe. So in the last 2 years, I know you've been incredibly busy. At the ECCC, as many of you may know, there are ongoing prosecutions of the former Khmer Rouge leaders for the events that took place from 1975 to 1979, during which time nearly 2 million individuals lost their lives. And so, Nick, it's my understanding that you've been primarily working on case 2 since you arrived, but perhaps you could just describe a bit more for us your role as the international prosecutor, a bit about the case that you have been bringing, and then also perhaps just enlighten us a bit more about this jurisdiction and why it is that we're doing trials now when these events took place nearly 4 decades ago.
Okay, thank you, Hannah. Well, the Extraordinary Chambers of the Courts of Cambodia is a court that was set up by treaty between the United Nations and the government of Cambodia. After the Khmer Rouge fell in 1979, following the invasion by Vietnam, the civil war continued in Cambodia until 1998. Elections, though, were held in the early 1990s, sponsored by the United Nations, and a lot of negotiations took place between the various parties. In all of these negotiations, states, particularly Western states, and even the current government of Cambodia, expressed the desire that there be some justice mechanism to bring to trial the most serious perpetrators of the crimes of the Khmer Rouge. So following long negotiations between the UN and the government of Cambodia, long and difficult negotiations about how the court would be structured and how much control the Cambodian government would have, or Cambodian judicial personnel versus international judicial personnel, an agreement was reached and the court started its work in 2006. One trial had taken place before I arrived. The trial and the appeal were finished, and that was the trial of Doik, who was the commander of the famous camp in Phnom Penh called S21, or Tul Slang, a school where more than 12,000 individuals were tortured and killed. That case had been completed before I arrived, but the second trial that took place was the trial of the senior leaders, originally 4 senior surviving leaders of the Khmer Rouge. The top leader, Pol Pot, had died in 1997, but surviving was the number 2 figure in the regime, Nun Chia, and also Khieu Samphan, who held the position of head of state. And at the time, during the Khmer Rouge regime, that's the person that most of the people in the West, and even many of the Cambodians inside the country, believed was the head of the government, because he held this public face position of head of state. Also, the foreign minister, Ieng Sary, and Ieng Sary's wife was the Minister of Social Affairs, Ieng Tarit. During the trial, Ieng Sary died, and before the trial, his wife, Ieng Tarit, was declared mentally incompetent because of Alzheimer's, so she was released from the case. But when I arrived, the trial had been finished, and the final arguments were pending. So I came in October of 2013, and we held final arguments over the course of a couple weeks, where all of the parties were able to state their position on what the evidence showed. The judgment in that case came out about a year later, August 7th of last year. And in that judgment, the both the two remaining accused, Nunchi and Khieu Samphan, were convicted and sentenced to life in prison. But let me explain something that's a little complex. I'll try to summarize it. It's difficult to explain this even to people in Cambodia who've been following the court. Because this trial was so huge, involving crimes that happened over 4 years in virtually all parts of Cambodia to millions of people, and many different charges, including forced marriage and genocide of certain minorities, the judges had decided at the beginning of the case in 2011 to sever the charges. And in the first trial, which we were arguing when I arrived, only the events of the first year or so of the regime were at issue. And those were the forced transfer of the population of Phnom Penh. When the Khmer Rouge captured Phnom Penh on the 17th of April, 1975, they forced the entire population, about 3 million people, to leave the city. And that resulted, including people in hospitals, women who were pregnant, with no really preparations for humanitarian care of those people. April, by the way, in Cambodia is probably the hottest place I've ever been. April is regularly 100-degree temperatures, and people were put on the road with little provisions for food and water. Many died, many were killed because of not following orders quickly enough. And then there was also covered a transfer later that year between various rural areas of the population. And one massacre that was relatively small considering the events of what happened in Phnom Penh, a massacre of at least 200 former soldiers of the former regime, of the Khmer Rouge opponent regime, the Lon Nol regime. So following that conviction, although that conviction is finished, of course, both accused have appealed. And the grounds of appeal are about 350 in total. One team filed 227 grounds of appeal, and the other about 150. That's pending. We haven't even done the oral arguments yet. I hope certainly that sometime before the end of this year we'll have the oral arguments. In the meantime, in January, we started the second trial of the same individuals. Now, some of you may ask, well, why do you have a second trial of people already sentenced to life in prison? And the answer is that, the trial is about more than putting these old men in prison. The accused now are, Khieu Samphan is 83, Nunchi is 89 years old. But the trial is also very, very much about recognition of what happened to basically the entire population. I would say the entire population of Cambodia suffered gravely during that regime. The first trial did not cover most of what happened. It didn't touch on at all the security centers like S21 and about 200 other security centers around the country where people were regularly tortured and killed. It didn't cover the forced marriage, which was a policy of the regime, where couples were forced to get married and forced to consummate the marriage, which we've charged that as rape. That remains to be covered in the second trial. The regime persecuted anyone practicing religion, Buddhists or Muslims, and that remains for the second trial. And there are genocide charges, which involved two minority groups, and I think probably we're going to get questions later about that, so I'll save that. So that's where we're at right now.
Thanks, Nick. I think I'm going to jump ahead to just actually that very issue of genocide. So one of the reasons that this discussion has been titled Decades After Genocide is because of the reality that in Cambodia, it may be surprising to all of you, the majority of the charges that have been brought on behalf of the majority of victims who died during that period are not genocide charges. The exterminations, the persecution are crimes against humanity and war crimes charges. to a layperson, that can be shocking indeed, because I think we all commonly understand that period in Cambodia's history to be one of genocide. So, Nick, I thought you could perhaps enlighten us a bit as to why that's the case and what the response has been, by, as you said, when you have nearly 20% of the population being killed, that affects the entire population if you think about all the families and the relatives. So what's been the response in Cambodia to this reality that there are not genocide charges with regard to the Khmer group, who was largely the most affected by the killings and the atrocities?
Well, for those that understand it, because frankly many people are not aware that the charges of genocide don't cover Khmer people, the dominant ethnic group. It's a bit of a puzzle, but what I found is when we are able to explain to them why that is, generally I haven't gotten a bad reaction. People understand. What I tell people, Cambodians and others, in our case, the most serious charges are not genocide. And why do I say that? The most serious charges are the extermination of political opponents of the regime, largely Khmer people. Probably, certainly more than 1 million people who were Khmer were killed by the policies of the regime, either executed or worked to death, starved by the policies of the regime. The genocide charges that we have involve two small groups. One, the Vietnamese, who were the traditional enemies of the Cambodian people. The policy of the regime in the first 2 years was to try to exchange or expel the Vietnamese to Vietnam, sometime to exchange them for Cambodians in Vietnam. But then in the last 2 years of the regime, the policy was clearly to kill all those that remained. But at that time, probably all those that remained were about 15,000, which is a very small number when you're talking about a total of 2 million killed. The second group that was targeted were the Cham ethnic group, which is a people of Malay. They come from Malaysia originally years and years ago, and they're practicing Islam. They're Muslims. And they were targeted, according to what we say, the prosecution alleges, to be destroyed, to be exterminated. And so why would we charge these two relatively smaller ethnic groups and not the majority of those who were killed, the Khmer people, the Cambodian people? The reason has to do with the definition of genocide. All of you have probably heard the word genocide, or many of you have heard the genocide called the crime of crimes, or understand, and this is the popular understanding, that genocide is the most serious crime possible. And I understand that. Many people call what happened in Cambodia an auto-genocide. And I have no problem with that term, but it's not a legal term. And it doesn't match the legal definition of genocide. So, genocide can have a political meaning and I think a legal meaning. The legal meaning is quite clear. It's established by the Genocide Convention of 1949. So what is genocide? Genocide are certain acts such as killing members of a group, creating conditions of life that would destroy the group, transferring children, preventing births, or inflicting severe physical or mental harm on members of a group. And this group has to be a religious, ethnic, national, or racial group. It has to be defined positively. One of the areas that's not covered in the definition, and it was discussed when the convention was being debated, I think it was in an original draft, was political groups. The Genocide Convention does not cover targeting a group of people who have only a political identity. It has to be racial, religious, national, or ethnic. So the targeting of millions of Cambodian people because of their political beliefs does not, in our view, fit the definition of genocide. So what I say in my case, the most serious charges, just on the pure numbers, are the extermination of the Khmer people and the enslavement of the people that resulted in all of these deaths, over 1 million deaths of Khmer people. There are genocide charges, but they're covering a more limited group of people, limited numbers of people.
So if I could just play the devil's advocate a bit further on this issue and press a little bit more. So when you think about the enormous impact that these killings have had on Cambodian society, they're still recovering to this day. When you're in Cambodia, there's been lots of studies on the trauma that the society has gone through, even 4 decades later. How important do you think it is, though, for a situation like that, where there is such organized, clear, systematic killings by leaders against a group, that it be labeled genocide for transitional justice purposes, for historical reasons?
Well, I think, as a lawyer, you only label something that fits the legal definition. And unfortunately, what's important is for people to understand genocide has a very technical legal definition. Under the technical legal definition, you could kill 2 people and be convicted of genocide because it's doing these acts against one of the groups I mentioned with an intent to destroy that group in whole or in part. So actually inflicting serious bodily harm on 2 people, but done with the intention to destroy the group, could fit technically the legal definition of genocide. It wouldn't in the ICC because they require that another element that the policy could result, in fact, in the destruction of the group. But under the Genocide Convention, even a killing of 2 people or even the wounding of 2 people could result in genocide. There's nothing minor about being convicted of the crime against humanity of exterminations, especially when that's the extermination of over 1 million people. So I think one of the things that people have to recognize, and it's important for victims to recognize and for legal professionals to educate the public about, is that you don't have to have that definition, legal term genocide, for the crime to be unimaginably horrendous.
Thank you. I could go on and on with this discussion with you, but we have a limited period of time. I want to make sure that we get to you guys as well. So turning a bit to another topic here. So as I've been mentioning throughout our discussion so far, the events that happened in Cambodia were 4 decades ago. A number of genocides or exterminations as crimes against humanity that are being prosecuted today from Rwanda, from the Balkans, occurred, quite some time ago. And then we have, of course, the Armenian genocide that took place around a century ago now, and many of the, many folks are still pressing for justice. With regard to the international criminal trials as a form of seeking justice for mass atrocities, what have been some of the challenges that you have faced in prosecuting mass atrocity crimes, and also the lessons learned when you're trying to do it so long after? And I guess a second part to that question is do you think there ever a point at which it's just too long after the situation where international trials don't really make sense and perhaps some other form of justice would be more appropriate?
Well, I'll answer the last first. I don't think that there's a time when it's too late to do the case or to hold people responsible. Now, the lateness could affect possibly what is the appropriate sentence, but I think many of you know that just, I believe it was this year, an individual was arrested in Germany for taking part in a massacre of about 300 people in Holland during the Second World War. So he was about, I think, 21 years old at the time. That took place about 70 years ago. He's now in his 90s. And the German authorities are pursuing him for the crimes committed 70 years ago. I understand that. I think that's important. The reason I reiterate that we do these cases goes far beyond putting a very old elderly man in prison for a few years before he dies. It has very much to do with a recognition of the harm that was done to the victims and their community, and an expression of the commitment of a society to do justice, to not let those go unaddressed. I think it changes in a very subtle way, but I think a very real way, the way people in a society view their society. Is it just, or is it something where the powerful have impunity and can get away with even the most horrendous crimes?
Thank you. And with regard to you bringing these cases personally, have you had specific challenges along the way, and how have you overcome those?
Well, the most difficult thing is in all of the international courts, we try to target those who are most responsible, which usually means they're at a high level of political or military authority. And the challenge then is usually, I mean, we have so many horrendous crimes where maybe, for example, in Cambodia, we had testimony about children in villages being swung against trees, toddlers being killed by being swung against trees. And we have on trial the person who was the number 2 of the regime and the head of state. The challenge is not so much proving that those children were killed as proving, well, what did the head of state and the number 2 in the regime, who didn't know the child, didn't know the man that swung the child against the tree, what did they do that make them responsible for that crime and the millions of other crimes that took place during that regime? What we call the linkage evidence. And this is why generally these cases take a long time. We not only have to prove that the crimes occurred, and we normally have to prove that they occurred on a massive scale, because that's part of the linkage, showing that the accused had to be aware of it. And knowing that, continued with various policies or assistance to groups or incitement of groups to make the crimes happen. We very rarely have a direct order: smash that baby's head against a tree, rape that woman. That's very rare. But so that we normally have behavior, policies, orders, past crimes that went unpunished that show that the policy of the regime was to use violence as a tool for their political goals.
So just dovetailing off of what you've just said, so part of the title is justice possible when it comes to genocide or to mass atrocities, exterminations? And when you're talking about millions being killed and millions more suffering, other abuses, it sort of begs the question of whether these are we asking too much of these international trials? Can they really achieve justice? Is there any form of justice really for such heinous acts? And you have quite a breadth of experience in international criminal law. You've worked on cases not only with regard to Cambodia, but also in Sierra Leone, Bosnia, East Timor. You've been at the International Criminal Court. So you have seen the lay of the land. You've been involved for quite some time in this area of work. And I wonder if you could give us your views on, first of all, how are we as the international community doing in using these trials, setting up tribunals or prosecuting at the domestic level, these types of atrocities, and trying to achieve some measure of justice? How are we doing in achieving justice, some form of justice, and particularly with regard to Cambodia through the ECCC?
Well, part of it is managing expectations of what can be achieved. Obviously, prosecuting cases is not going to bring back those who were killed. It's not going to result in financial compensation for the millions of individuals, or even if it's tens of thousands, or even if it's hundreds, who were victims of crimes of the individual accused. But what it does, I think, is still important. And I say that because I've heard victims say that. For them to see people go unpunished is like putting salt on their wounds. It makes the suffering even greater. And to see some recognition, particularly by an international court, of what happened to them, gives them some measure of satisfaction that the suffering that they endured has been recognized, and that it's recognized that certain individuals were responsible for that. I remember one man who testified, and he was a Muslim preacher, an imam. He had had both his hands amputated. He testified in the Taylor trial, and at the end of his testimony, the judges thanked him, and he broke down crying. Now later, as we normally did, we met with him just to ask how it went and thank him for his testimony. And he said, he wanted us to know why he had cried. He said, the reason I cried at the end of my testimony was because I was so happy. I was so happy that I was here in Europe and these judges from different countries and around the world were listening to the story of what happened to me. And he, in fact, wouldn't let us leave without he wanted to say prayers for us. He was grateful for having the opportunity to testify. And in that case, he testified, and across the room was the president of the neighboring country that most people felt was the person most responsible for the war and for what happened to him. So I think that this measure of satisfaction of victims in the recognition of their suffering is tremendously important. Again, it doesn't bring people back to life, it doesn't amount to financial compensation, but it amounts to some type of moral recognition of what happened to them.
So, with regard to the victims and their perspective, unfortunately, the reality with these trials is that, as you know, they're focused on specific individuals. We can't possibly prosecute all of the individuals responsible for perpetrating something as large as a genocide. It's just not humanly possible to do that all in one case, in one trial. And so we're focusing on, specific high-level leaders, usually in international criminal trials. And the consequences of that, of course, are that not all victims get to testify in court. Not all victims get to be, their suffering and their pain gets to be recognized within the limited parameters of a one individual case or, a couple of cases. If you look at the track record of many of our international tribunals, the caseload that they've managed to get through, while impressive, has not nearly covered the enormity of what has happened in many of these affected societies. And so a question that I always, I ask this of my students in international criminal law, and I always struggle with it a bit, in part because I come from an anthropological background where I've worked in the field and I've talked to survivors of mass atrocities. And the question that's always nagging at me is, since Nuremberg, since Tokyo, since World War II, and then especially following the Cold War, we've seen a proliferation of these trials as, a major form of justice or seeking justice for these mass atrocities. And yet they're very limited in what they can achieve. The cost of them is enormous. And the results are limited, and it doesn't nearly touch all of the victims that have been impacted. And so is there, are we doing the right thing as an international community, as the international community, by focusing on these trials so much? Should there be, other forms of justice alongside? And I know with regard to Cambodia in particular, a society that is coming out of situations of deep poverty, there is still quite a lot of poverty in Cambodia. One criticism of this court is that the international community should have come in with more development aid. This money should have been used for something else. And so how would you respond to those criticisms? But also, is there ever a situation you think where perhaps we should think about other forms of justice?
Well, I do think the other forms of justice we should think about. And in many of the courts, there is some complementary mechanism. So, for example, in East Timor, we both had prosecutions of perpetrators of the more serious crimes and a truth commission to deal with perpetrators who had committed less serious crimes, where people would simply go before the community, confess what they did, and then maybe their punishment is to rebuild a house or to do work like that. Similar, of course, in Rwanda, where hundreds of thousands, I believe, of perpetrators went through the local traditional courts and received, some of them were sentenced to prison, but the majority of them received this type of sentence of sort of community service. So it's possible to have complementary mechanisms. You can have an international tribunal and also national prosecutions that just taken place in the Balkans, where lower level perpetrators have been and continue to be tried in national courts. But the cost of the courts is high. The results have been slow and limited. I mean, I am definitely a proponent of doing everything possible and thinking as creatively as possible about how to make these cases go more quickly, how to make them more efficient. I think we have put forward some proposals. You're never going to make it really quick because they're extremely complex cases. And to have a process that'll stand the scrutiny of time and historical scrutiny It takes time. It takes a lot of evidence. It takes a lot of opportunities for the defense to look at evidence and disclosures. In the Cambodian court, I think in the trial to date, we have at least 200,000 pages of documents and evidence in that case. In the former Yugoslavia, the total database of the Yugoslav Tribunal of the Office of the Prosecutors has now reached 10 million pages. 10 million pages of evidence and documents. So these are always going to be complex. Is it expensive? Yes. The Tribunal for the former Yugoslavia has cost $1 billion. It's 22 years in existence. It's had some impressive results. Milosevic was put on trial. Right now, the leader of the Bosnian Serbs, Ratko Mladic, and the president of that entity, Radovan Karadzic, both are on trial. Many people thought that that court would only try camp guards or individual perpetrators. But critics will say it cost $1 billion, and you could use $1 billion, can save a lot of people put into healthcare. But also $1 billion is less than the cost of an aircraft carrier. It's the cost of about one B-1 bomber. An aircraft carrier is about $4 billion. So can you spare one B-1 bomber to have a mechanism to bring some measure of justice for hundreds of thousands of victims? I think it is a good investment. If you take the money from the courts of Cambodia, if they hadn't been created, if the donors had not funded the court, would that money have gone to alleviate poverty in Cambodia? I don't think so. It's not a trade-off one for one. So in my view, everything should be done to make the courts more efficient, to make them faster, but still overall, I think it's a worthwhile investment.
Great, thank you. So I'm just going to wrap this up with just one more question and then open it up for the rest of you. If I could bring it back to you personally, Nick. There's a lot of students in the room who are contemplating their future careers and thinking about making decisions about moving forward. And I hope, it's my hope, that many of you are thinking about using your lives to seek justice. And Nick is a wonderful example to us of someone who has done that, has dedicated his life to seeking justice by in his skill as a prosecutor. And so Nick, I'm wondering, putting yourself back in their shoes, who knows, way back when, what kind of advice would you have for them at this point in time in their lives as they think about how to make the right choices and the right moves? And what did you learn along the way in getting to where you are now after being a prosecutor in LA and now at the international level? First, this international tribunal world is very, very small. I have to say that. I was incredibly lucky, and just pure lucky, to get into it. The hard thing is to get that first job, to get your foot in the door. But also to do that, what I did and many others did, of course, is to take a bit of a risk. I fortunately had a leave of absence for 2 years from the DA's office when I started, but I ended up never coming back. But I took a pay cut, and I've done that a couple times, even a 50% cut in salary. Also, I think part of the reason I was able to get my foot in the door for the first job is because I had done volunteer work. I'd worked for the American Bar Association in Armenia and in 3 other countries. So I think if you're really interested in this field, in the international field, if you have any opportunities to work overseas, I think those are very good. If you can afford to do an internship or do some type of volunteer work, I think that will make you a stronger candidate. Foreign languages, of course, are always useful. But I also would say that while my world is divided between those of us who've had domestic experience and those who kind of always came through the international law, usually the academic side, and started as young lawyers without having domestic experience, I'm glad I had the domestic experience. And I think we all see, especially in trial, if you're talking about trial lawyers, there's a great advantage to having participate in something like, particularly an adversarial system like the United States, doing a lot of cases and being used to questioning witnesses, cross-examining witnesses, thinking and talking on your feet. American lawyers often
and British lawyers, for example, seem to have an advantage in that because our systems require that. You build up that experience. So I would encourage people to think about a domestic career, also because this international field is very competitive and difficult, but to try to do that and pursue international opportunities when they do arise.
Great, thank you. So now it's your turn. We have about 10 minutes left, and we do have to, I understand, be finished by 1 p.m. And so I would like to invite anyone who might want to ask a question to come forward. A few things. We do have a microphone here, and we ask, because it's being recorded, that you come up and speak into the microphone. Also, this is just an opportunity for you. It's a unique opportunity for you to ask Nick a question, so we ask that you keep it limited to 1 or 2 sentence question for him, and so with that, I will I invite you to come forward.
Hi, thank you, USC, for the opportunity. I'm here with the students of Rosa and Alex Pilibos. We were just wondering if you can comment specifically on the case of the Armenian genocide and what legal possibilities we have for justice, especially considering all of the perpetrators have passed. Thank you.
Right, thank you. Well, as you mentioned, the type of work that I've been doing, international criminal law, involves the individual acts, the individual responsibility of people, commanders, politicians. It doesn't involve the responsibility of a state. Because the individuals are deceased, the case, you cannot have that type of case. When Ing Sari, the foreign minister, died, his case terminated. We don't try dead people in the international courts. But as I think many of you are aware, there are several other legal initiatives that have gone forward and continue to go forward, that involve some recognition of what happened, everything from claims to property, which I think is an area that could be very fruitful in litigation and has been, and to issues about whether people are persecuted for speaking their views of the historical truth. Those are the types of legal litigation that can take place at this time.
Thank you very much for a very useful discussion. My name is Dr. Simon Simonian. We are trying to solve a problem and bring justice. The question is, how could we prevent the problem occurring in the first place? By what steps should we take to prevent genocides and violence of this kind, both ethically, morally, and legally?
Thank you for that, Dr. Simonian, for that very important question. I think that this is critical. Right now, I've been talking about things that happened 40 years ago, former Yugoslavia, 20 years ago. These types of crimes are happening today. They're happening in places like Syria and Iraq, in Myanmar. Anyone who's against genocide should be against genocide or crimes against humanity anywhere they occur, against any people. So I think part of what we can do, I think it's important to continue these processes of holding to account those from even cases like Cambodia that took place 40 years ago, because I think it does have a deterrent effect. Certainly it's not going to stop all atrocity crimes, but we prosecute murder and rape in Los Angeles. Does that mean we've stopped all murders and rapes in Los Angeles? No. But would it be worse if we didn't? I think most of us think it would be much worse. There would be more murders and rapes if the perpetrators knew there was no chance of being prosecuted. So I think there must be solidarity among the communities around the world to see that those who perpetrate these crimes are held to account, that whenever possible, the international community act as one to stop genocide and these crimes from happening, even by force when that is necessary. There's an initiative now, I know that some civil society groups are taking to try to get pledges from the 5 members, permanent members of the Security Council, not to use their veto in referrals of these kind of humanitarian cases of serious violations of international law to a tribunal. And it really arose out of attempts to refer the situation in Syria to the International Criminal Court, which was vetoed by Russia. And so these civil society groups are pushing to have the 5 permanent members make a pledge not to use their veto power in this type of situation. So I think all of us can have some effect by simply condemning what's happening around the world, recognizing it, having early warning signs when it's about to happen or when the signs are there, and calling on the major states, the powerful states, to take action, to do what they can to prevent it.
Anyone else?
Hi, thank you for being here, first of all. Has the fact that the ECCC is located within Cambodia affected your work personally or the case at all, in your opinion? Thank you.
You know, I've worked in, I think, 4 other tribunals, and this is the one where there's some unique aspects to Cambodia. One is that the victims actually participate as parties, which is part of the French civil law system. So when I go to court, and when I gave my part of the closing argument in that case, 2-1, behind me there's a row of people who experienced what happened, who had their mothers, saw their mothers and fathers starve to death or executed. Some of them had their children killed. And they're sitting behind me. And that has a tremendous, I think, effect on understanding and bringing home to you the importance of what you're doing. In the courts in Cambodia, the court has done a very good job of bringing people out to the court, busing people from villages, from schools. So far to date, over 200,000 people have viewed at least part of the proceedings in that court. So I think it's a very positive effect that we're doing this case in the country, in Cambodia.
Great, so we have time for maybe 1 or 2 more questions. Anyone else want to come forward at this time?
Thank you again for coming. It's a 2-part question, I guess, sorry. One was, I think you said it was such a precise legal definition. And it was in 1940s. Has any movement to maybe change it a little, throw in other aspects, as any efforts of that come about? And another part was, I believe you said that most of the things you're doing don't exactly have reparations, financial compensation, etc. Are there any movements for, let's say, the Cambodian government, or at least I'm more familiar with the Armenian genocide? Yeah, you give it.
Thank you.
Thank you. Yeah.
Thanks. Okay, so thanks for those. Those are both good questions. On the reparations, thank you for that question, because I should explain, well, what I talked about is there wasn't much chance of individuals getting any financial compensation for what happened. But because the civil parties participate, the victims participate as civil parties in the case, the court will order, and they have in the other trials, order what they call collective and moral reparations. So those are things like, and they require that there has to be funding obtained before they order it. But things like, for example, the judgment was printed, the names of the victims were printed in the judgment, and that was distributed around the country. Memorials were done in various locations to those that died. Psychological treatment was provided to victims, particularly of sexual abuse, in various areas of the country. So the courts have ordered, in Cambodia particularly, these collective and moral reparations. In the Lubanga case at the ICC, we're still awaiting, that case finished some time ago, but still awaiting the order of the court of what type of reparations they will order. It's clearly not going to come from money of the accused. Sometimes when you have one person killed by one person, the court can order, if they have money, that they provide some compensation. That's not going to happen in these cases. But some kind of symbolic, collective, moral reparations can be ordered, and that can be important. And your other question was about, I've forgotten.
Like language
Yes, or the genocide statute. I'm not aware of anyone. There probably is someone in the world talking about amending the statute, but I'm not aware of any serious effort to amend the statute. But there continues to be an evolution of the jurisprudence about what those words mean. The statute says destroy in whole or in part. I think our case that's going to be judged, that we're in right now, involving particularly the one against the Cham Muslims, is going to be very interesting and may help the development of this jurisprudence, because what does it mean to destroy the group in whole or in part? Many Chams survived. They died in higher percentage numbers than ordinary Khmers, ordinary Cambodians. Maybe 34% or so of Chams were killed versus 25% of Khmers. But what I would say our evidence shows is that the regime told people, if you practice your religion, if you have the identity of Cham, if you practice Islam, if you refuse to eat pork, if you speak your language, anything that asserts your identity, you would be killed. And the evidence shows that leaders of the regime, religious and political, of the group, the Cham Muslims, religious and political leaders of the Cham were particularly targeted and died in extremely high numbers. They were almost completely wiped out. So in my view, this kind of conditional threat that if you assert your identity, that those that do assert their identity will be killed, of course that will result in the destruction of the group. And the group will not survive for generations as a distinct group if they are prevented from asserting their identity.
So with that, unfortunately, I have to bring us to a close today, but I just want to thank you again, Nick, so much for joining us here at USC. You have a very busy schedule, and I know that it's just quite an honor for you to be here today. And so thank you for taking the time, and thank you, most importantly, for the work you're doing. It's really just on behalf of all of us. I think we want to honor you today for the work that you're doing in seeking justice in many parts of the world.
Thank you for the invitation, Hannah. I very much enjoyed it, and Selfie, thank you very much for arranging this for me.
Thank you both. Thank you. I think that the nature of the crime is such that the pain, whether it was inflicted 20 years ago or 100 years ago, is so deep. It is very difficult for victims, those involved in any way, engaged in any way, to find the space, the human, intellectual, spiritual space to include others who have gone, are still going through similar pain. And I think that this discussion was valuable for many, many reasons. And for me, especially that it was, that it recognized the universality of the crime and its implications. Thank you. The commercial. Our next luncheon talk on the 16th of September. The guest is Professor Armen Marsoubian, and the interlocutor is Professor Varun Soni, head of the Dean of Religious Life. Armen Marsoubian is a professor of philosophy at Southern Connecticut State University, but the reason he's coming is because he is among the very rare of survivors, descendants of survivors, who has photographs of basically a way of life, a place, a people that were lost. I personally have none. I have one small photo of my grandfather, who I never met. The fact that he has volumes, hundreds, says so much about the loss, the way you remember, what you remember, and we've called the talk The Presence of Absence. And that's here on the 16th, and we do hope you all come. The photographs will be here as well. Thank you, and thank you.